Okay, thank you so much for joining us tonight for this month's Family Protection Planning webinar series. We are welcoming Scott Grayson with Grayson Law Firm here in Denver, Colorado. Scott is an estate planning attorney. He's also experienced in employment and civil rights law. He helps his clients plan for incapacity and death through the use of wills, trusts, powers of attorney, and living wills. And tonight he's going to talk with us a little bit about estate planning. What is it? Why it's important, and then also planning for incapacity and death through the various documents that you'll need. So thank you so much, Scott. It's great to have you.
Great. Thank you, Nicole. It's great to be here. All right. Let's see. All right. Can you see my screen there, Nicole?
Yep, looks good.
Awesome. All right. Well, thanks everyone for having me. I appreciate it. My name is Scott Grayson, and I'm with Grayson Law Estate Planning, a full service estate planning law firm here in Denver, Colorado. And tonight I'm going to talk to you a little bit about wills and trusts and why estate planning matters. So a little bit about Grayson Law. I founded Grayson Law back in 2021 with the goal of giving my clients control over the estate that you guys all spent a lifetime building. My approach to estate planning, I call it the good, better, best approach. That means I don't tell you what you have to do. I try to give you options. I'll give you the good option, the better option, the best option. And as you can imagine, as we go from good to better to the best, the price can go up a little bit because as we get to that best category, things get a little bit more complex. But the advantage I think we have of structuring things that way is I can give you guys a good plan that will work for you. May not necessarily be the best plan, but a good plan that'll work for you at a price you can afford. So tonight, I want to talk a little bit, or tonight, I'm going to go through the agenda here. I'm going to talk about the purpose of estate planning, what you need to know about wills and trusts, how to choose an attorney, and taking action. So when we talk about estate planning, what is the whole purpose? Okay. Two words, taking control. All right. If you have an estate plan, you're setting out what you want to happen when you pass away or when you become incapacitated. Okay. If you don't have an estate plan, then what will happen is determined by Colorado law. And I'll be honest with you, if you ask me a question about, well, this is my family situation, I don't have a will, what'll happen? I'll have to go look it up. That's how complex it can get and how hard it can be to be able to predict what'll happen. And just because you think something will happen today doesn't mean that the Congress or the legislature isn't going to change the law tomorrow to have something different happen. So when you create an estate plan, you're putting everything right down in writing exactly what you want. So when we talk about an estate, what exactly are we talking about? Most people, when they think of an estate, it's the stuff you own, right? Things, bank accounts, life insurance, home, real estate, maybe you own a business, all of your personal property. But I expand on that a little bit and I include your family, your values, and your legacy. So when I'm doing your estate planning, or when any good attorney's doing your estate planning, they're not only concerned with what's happening to your assets, but they're also concerned with what's happening to your family. Is that estate plan that they're creating, is that fostering family harmony, or is that going to cause fights? Um, there are ways that we can actually incorporate your values into an estate plan. We can set it up in such a way that if you want to encourage your kids to go to college, maybe we can give them a little extra distribution out of a trust if they go to college and get that college degree, that sort of thing. And then your legacy, that's just making sure that, like I said earlier, that estate that you built your lifetime building, it's going to go to your family. We're not going to talk a lot about taxes on this webinar. It's a bit of a more advanced subject, but we can do planning in a way to try to minimize the amount of taxes that your estate will have to pay, and thereby letting more money go to your family. So some of the goals of estate planning, more specifically, you can think of it as being able to give what I have to whom I want, the way I want, when I want. Okay. Another goal is caring for yourself during a period of incapacity. Also caring for and protecting others. So, for example, maybe you want to make sure that your surviving spouse is protected, or you have a special needs child that you need protected. Minimize or eliminate probate. So, once we get into talking about wills versus trust, we'll talk about probate a little bit more. Fulfilling charitable intentions, we can structure a plan so that you can give money to your favorite charity. Pass on values and ideals. So, like I mentioned on the last slide, we can set up a trust in a way so that you can, we call it controlling your family's lives from beyond the grave a little bit. But we can put stipulations in trust to try to guide family members in a particular direction. And then also maximizing assets and protecting assets as well. So what should you consider when you're creating an estate plan? There's quite a few things here on this slide, and I'm not going to read through all of them. But the major things I wanted to point out is, do you have minor children? And if your children are adult children, are they financially responsible? Do you or your spouse have children from a prior marriage? And have you considered what will happen if you can't make decisions for yourself? These are all things that we can handle in an estate plan. So key definitions, like I mentioned, we're not going to really talk about taxes much in this webinar, but probate is going to come up quite a bit. Most of you probably heard of probate, but you may not know exactly what it is. The best way to think about it is it's just the official court proceeding that winds up your estate after you pass away. So when you pass away, your family would have to go to the court, take your will, or if you don't have a will, go to the court and essentially go through this process that can take about a year, maybe up to 2 years, depending on how complex your estate is and kind of how in order all your affairs are. And it's a lot of paperwork. A lot of people have to end up hiring an attorney to help them get through it. But essentially, what happens is you can't really take that next step in the process of distributing the assets and making sure your heirs get your property without the court approving everything. And like I said, it can get complex and it can be annoying. So a lot of people end up hiring an attorney. Now, there are ways that we can set up an estate plan to try and avoid probate. And that's what we're going to get into when we talk about wills and trusts. So a lot of people think that one of the major reasons that you do estate planning is to avoid the estate tax. And that's not actually true. Currently, the federal estate tax exemption is about 13 million. Most people don't have estates that come anywhere near that, so they don't even have to worry about paying the estate tax. But other reasons, if you're well under that 13 million, like most people, other reasons to make an estate plan, like I mentioned earlier, family harmony. You want to make sure that your children, maybe an aunt or an uncle or somebody aren't fighting with each other to get property. With an estate plan, you can lay everything out. I want the house to go to my daughter. I want my car to go to my son. Okay. Once it's in there, it's in there. That's what's going to happen. Like I mentioned, also legacy planning, right? You're making sure that estate that you built, that lifetime building, is going to your family. It's staying in your family, going to the people that you want it to. We can also use estate planning for some asset protection. So maybe you have an adult child who's maybe not the most financially responsible, maybe is having some issues with creditors, maybe some drug and alcohol issues. We can set up a plan in a way to try to control or to try to protect those assets that are going to them from their creditors. Okay. And in some cases, we can even try to do some income tax planning to try to make sure that your heirs are able to keep as much money as possible. All right, so let's get into the wills and trusts. So what you need to know about wills and trusts. So one thing I wanted to mention is when we talk about a trust, there's a lot of different types of trusts. And we can create these for pretty specific reasons. So we can create a charitable trust if you want to make sure that you're leaving money to a charity, a special needs trust if you have a special needs child or a special needs family member. But generally, when we're talking about a trust as part of an estate plan, we're talking about what's called a revocable living trust. And that's what we refer to as a will substitute document. And you can just think of it as exactly that. In a will-based plan, the will is the central part of your plan. In a trust-based plan, that revocable living trust is the central part of the plan. So tonight, when I say trust, I'm referring to the revocable living trust. Just keep in mind that there are a number of other types of trusts that we can create to take care of specific situations. So when is a will the most appropriate document? The simplest way to think about it is when you have a simple estate with few assets. Um, so maybe you're just starting out, maybe you have a house, maybe you just got married, no kids yet, don't have a lot of assets that you have to worry about. A will could be perfectly appropriate for you. In that case, probate, you would have to go through probate if all you have is a will. But if all you're looking at is a house and not much in other assets, then the probate process really won't be that bad. Another reason why you might want a will is if you anticipate litigation. If you're anticipating some family members maybe attacking your will or somehow trying to get part of your estate, having the will go through that probate process, that court process, can actually be a good thing because there's already a judge involved. What are some of the dangers with wills? Well, wills are pretty limited. Like I've mentioned before, wills must be probated. So there's that process that you have to go through. Wills can be problematic if they have to cross state lines. So for example, one thing that's popular these days is investment properties. I talked to several clients who own real estate own real estate in different states. If you have a will, then your estate is going to have to go through probate in every state where you own property. One great example is I actually have a neighbor who is a college professor, and he teaches at CU right now, but he's taught at Ohio State, Maryland, Florida, and Arizona, I think, and he owns houses in every single one of those states. So if he were to pass away, his wife would have to do probate in Colorado, Ohio, Maryland, Florida, and Arizona. So that's one area where a will could be very problematic. Wills, they only provide direction and protection for a short time, whereas a trust, we can put some provisions in a trust, like I mentioned earlier, to kind of provide direction for a longer term. Some facts about probate here. One thing to keep in mind is that probate, because it's a public court process, your will, once it gets lodged with the court, it'll be a public record. And so people can go out and they can look at your will. They can see who's going to be inheriting money from you. They can get an idea of how much people are inheriting. Some people just from that aspect don't like probate. Probate can be complex. Many people end up hiring an attorney to help them with probate. Now, one good thing about Colorado is Colorado is one of a number of states that have passed the that have passed the Uniform Probate Code. In Colorado, we call it the Colorado Uniform Probate Code. But the intention of that is to try to streamline the probate process, take some of the complexity out of it. So if a member of your family who's handling your estate, if they're pretty good at filling out forms and dealing with bureaucracy, then they might be able to make it through that probate process themselves. A lot of people, they just don't want to hassle with it, so they end up hiring an attorney. Probate can be a long process. What I tell clients is expect about a year for even the simplest estates. A lot of it is just sitting and waiting for the court. We fill out the forms, we turn them in, and we wait for the court to respond. and there's no guarantee that it's going to be 4 months. There's no guarantee it's going to be a year, but generally we tell people to expect a year. Probate, as you can imagine, can also be expensive. You have to pay attorney's fees. You have to pay court costs. So the expenses can rack up with probate. So when should you choose a trust? Um, the main thing to see here is when you want to keep control over your plan during your lifetime. And you also want to outline what will happen in the event of your disability. Trusts are great documents for doing that. And so here's an example of how you can kind of uh, control your distributions after you pass away when you create a trust, right? You can have everything go to somebody outright. That means they just get a lump sum of money. But let's say you have a child who's maybe a minor, or they're just in their early 20s, and you don't want them to have access to all that money right away. So with a trust, we can set up those distributions in stages. So for example, at age 25, you receive a certain amount. At age 30, they receive a certain amount. Age 35, they receive a certain amount. We can also put other stipulations in there. Like I mentioned before, if they graduate with a bachelor's degree from an accredited college, they can receive a little extra money. That's something that I put in a lot. I've had clients who have asked me to put in provisions requiring prenuptial agreements when their children get married. Um, um, Also, some of my more entrepreneurial minded clients have me put something in the trust allowing an extra distribution if the child wants to start a business, things like that. And so with a trust, right, you can create these provisions for your spouse, minor children, and adult children that will, like I've mentioned a couple times before, kind of control how that money gets distributed to them after you pass away. They're not just getting one huge lump sum of money that they can go and blow at a wild weekend in Vegas. We can also set it up to protect your assets from creditors and predators. One of the things that turns off some people to the probate process is if, especially if you have a large estate, once that will gets lodged with the court and it becomes a public record, um, you're potentially opening up your heirs to con men, to predators, people who just don't have the best interests of your family at heart. So by going with a trust, you don't have to go through that probate process. You can keep everything a little more private. Can't guarantee privacy, but we're at least keeping the documents in your estate out of that public court process. With a trust, we can also incorporate some of your values. We can include charitable giving in your trusts. If you have pets, we can plan for your pets with a pet trust. If you have firearms, there may be some instances where a gun trust would be appropriate for you. So those are some of the things that we can do with trusts. So I want to talk a little bit about finding the right attorney. So obviously, not every attorney is going to be right for every type of client. I like to think that I'm the greatest attorney in the world and that everybody loves me, but I can tell you for a fact I know that's not true. I've actually referred some clients that I've done consultations with to other attorneys, just because the client didn't think I was the right fit for them, and I have no problem doing that. I have a list of other attorneys I'm always more than happy to refer people to. But some of the things to look for when we're talking about an estate planning attorney. First big question is estate planning their primary focus? I promise you that there's probably not a great estate planning attorney out there who is also an attorney in some other field. So if you see somebody who's advertising that they do family law, estate planning, DUI defense, and things like that, and a list of things like that, chances are they're not going to know it. They're not going to know a lot of the ins and outs of estate planning and in special situations that you could find yourself in. But somebody who specializes in estate planning and makes it the focus of their practice, they're probably going to be up on a lot of the new laws, new guidance that's coming out from the Bar Association, and things like that. Another question to ask is, does your attorney practice collaborative based planning? And what I mean by collaborative based planning is, does your attorney, are they going to work with the other financial or the other professionals in your life? Is that attorney going to talk to your financial planner and make sure that your estate plan fits in well with your investments? Are they going to work with your CPA to make sure that they're uh, not creating a trust or doing something in some way that's going to cause tax problems for you or your heirs? Does the attorney charge a flat fee or an hourly rate? This one I think is a big one. I actually do not know any attorney who charges an hourly rate for an estate plan. Probate's a different matter. Most attorneys will charge hourly for probate. But for estate planning, most attorneys will charge a flat fee. And the advantage of that is obviously when you go into the relationship with the attorney, you'll know exactly how much money you're going to have to pay. Now, obviously, if there are things that come up during the course of drafting your will or your trust that we didn't anticipate, sometimes a little extra charge will have to get added on. But I know that I do my best to go through with the consultation and the design process with you. I try to make sure that I ask all the right questions to get all the information I need so that the day I start drafting your plan, you know exactly how much it's going to cost. Does the attorney have a process in place to keep your plan up to date? So estate planning is not a one and done thing. Uh, People's lives change. You have kids, your kids grow, they become adults. Maybe you sell your house, buy a new house, you could accumulate more assets. You get married, maybe get divorced, people in your family pass away. All of those things are reasons why you might want to update your estate plan. So having an attorney who has a process in place to help you keep things up to date is always a good thing. And of course, ask yourself if you can see yourself working closely with an attorney. I'll be honest with you, when I'm talking to my clients, we sometimes get into pretty personal conversations. Um, I have clients who've had to tell me about problems that their children have been having with drugs and alcohol, for example, so we can appropriately plan for those things. So that person that you're talking to is somebody that you have to be able to see yourself potentially um, giving some pretty personal information to. Another thing to think about when looking for an estate planning attorney is, are you getting a comprehensive estate plan? So estate planning is not just about what happens when you pass away. It's about what happens when you become incapacitated and can't make decisions for yourself as well. So it's kind of two sides of the same coin there. So we talked about the will or the trust. That's your document that handles your affairs after you pass away. But then you have the healthcare power of attorney. So that's the document where you name someone to make medical decisions for you. If you're in a state where you can't make those decisions for yourself. A durable power of attorney, it's similar to the healthcare power of attorney, except the durable power of attorney covers your financial affairs. And there could be any number of situations where you could find yourself in a place where you can't access your bank account for some reason. You need somebody to do it for you. A perfect example is just this past Monday, Monday evening, actually, I was down at the Arapahoe County Jail. Someone had gotten themselves into a little bit of trouble. He was in jail. Um, I really don't know how the bonding process works, uh, honestly, but for some reason he could not access his bank account to post bail and get out of jail. So a friend of his had to go find an attorney, us. Um, we drafted a durable power of attorney for him, drove down to the Arapahoe County Jail, went in, got him to sign it. We notarized the document and left. So he spent an extra few days in jail just because he didn't have somebody who could access his bank account for him. And I'm not saying that anybody listening here is going to end up in jail, That's just an example that you just never know what's going to happen. And incapacity isn't always that you're laying in a hospital bed in a coma. If you're locked up in jail or something else happens and you can't get to those bank accounts, you're considered incapacitated. A HIPAA release, or excuse me, I skipped one here. The next one is the Advanced Medical Directive. Most people know that is a living will. And this is a document where you express your end of life wishes. So if you're diagnosed with a terminal condition, you can't communicate with your doctors, and your doctors need to know if you want to be left on life support, removed from life support. That's what this document is for. A HIPAA release. So HIPAA is the Health Information Privacy Law. And essentially what it says is that doctors, insurance companies, hospitals, they're not allowed to disclose your personal health information to anybody. So what the HIPAA release does is that tells the doctor or the hospital who they're allowed to talk to about your condition. A personal property memorandum. This is a great document. It lets you essentially just write in pieces of tangible personal property that you want to leave to people. So maybe you have your set of lucky golf clubs, or a sentimental knickknack or something that you want a certain person in your family to have. You can just write that in the sheet. Okay, it's really flexible and it's really great. It's a great way for you to specify who you want to get to have certain items without having to constantly go back to an attorney to have your will or your trust amended. And then the last thing is your memorial instructions. Some people call it a disposition of last remains or burial instructions, but this is where you can tell your family, your heirs, how you want what you want at your memorial service. Do you want to be buried, cremated? Do you want to have a 21 gun salute? A pool party? Anything like that. You can include that in the memorial instructions document. So when you're talking to an attorney, if they're not talking to you about including all of these documents in the package, there's a good chance that they're leaving out something that could end up being really important. All right. So I want to talk a little bit about DIY plans. Now, I'm a DIY person myself. So I can understand the temptation to want to create your own plan, and there are ample resources out on the internet for doing that. Just a couple of things to be on the lookout for. One is that these plans may not comply with state law. I've heard stories about some of these companies. They hire people to write uh, their templates, these cookie cutter wills and trusts, and the folks are not attorneys who practice in a particular state, so they don't exactly get the law right. There's also no personalized planning. Everybody, what I find is that most people, they're all a little bit different. Most plans that I do, I can't just take a template and fill in names and have it be done. Um, there are certain provisions in there that I have to go in and change just to make sure that that thing fits their particular family situation. So with these cookie cutter design plans online, you may miss that, and you may end up with something that doesn't quite fit your personal family situation perfectly. Another danger with these online plans is that uh, it's left up to you to fund the trust. Okay, so when we talked about trusts, one of the really critical aspects of the trust is making sure you fund it properly. And so that's taking your assets and putting them in the name of the trust. So, for example, your house. When you create the trust, we'll deed your house into the name of the trust so that technically the trust owns the house. You're the trustee of the trust, so you still control the house, but technically on paper, the trust owns the house. And that's really important because if you don't properly fund your trust, then that trust is not going to control your assets. Okay. So what that means is you can write in your trust that you want your oldest daughter to get your house, but then you don't fund the trust with the house. Guess what? That trust does not control what happens to the house. The house then ends up having to go through that probate process. So, and so people oftentimes we see they'll create trusts online, but then they don't fund them properly. Right. So I wanted to talk to you a little bit about my process. I've talked to quite a few other attorneys, especially early on when I was getting started. The estate planning community in Colorado is great. Attorneys are always willing to help each other out. Um, and so the process that I came up with is probably pretty typical of what you're going to see with a lot of other estate planning attorneys. The first thing I do is I have a consultation. And a point of that consultation is to just get to know each other a little bit, establish a relationship, see if I'm somebody that you're going to be able to work with. We're going to talk about your objectives. I'm going to learn about your family and assets. And I'm going to start asking you if you work with other professionals. Once we get past that point and you decide that you want to move forward, then we'll schedule another meeting and we'll actually design your plan. And that's where we get into what I mentioned earlier, some of those kind of personal questions. I'll um, I'll get into particular aspects of your family, who you want to leave certain items to, who you want to get your house. Like I mentioned before, you're like your lucky golf clubs and things like that. We'll also establish your priorities. Like, what is the most important thing to you? Is it planning for a special needs child? Is it planning for an elderly parent potentially? Is it making sure that your spouse is taken care of? We'll go through all of those priorities and we'll come up with what is the best plan for you. Once we do all that, you're pretty much done. Well, you're done for a little while anyway. I take all that information and I go off and I draft your plan. After I finish drafting your plan, I'll let you know that it's done. And we'll get together, we'll review everything, make sure it looks perfect and that you understand everything you have. If there's anything that I got wrong or that you want updated, I'll go back to the drafting stage and I'll fix everything. And then once everything's been updated, I'll come back to you, show you the plan. And then once everything is perfect and you understand everything that you're getting, we'll do what's called a delivery meeting. That is essentially where we just sit down and we sign all the documents. Um, we'll have witnesses, a notary, and we'll get everything taken care of. The next step is implement the plan. This is typically when we do trusts. Um, this is the trust funding stage that I mentioned earlier. So at this stage, I'll do your deed, move the deed to your house into the trust. If there's some other assets you have that we have to fund into the trust, I can do that for you, or um, I can give you instructions on how to do that yourself. And then we monitor and update the plan. And typically, what I recommend to people is that every year they kind of go through the plan themselves, just ask themselves, has anything changed? Has anyone passed away? Um, has a child turned 18 or 21? Anything like that. And then every 3 to 5 years, I recommend that they come back to me and we sit down together for an hour and we just go through everything, make sure that everything is up to date. Okay. And so the last step is to take action, is to actually get out there and make the plan. So, what are your risks if you don't have a plan? So, your major risk is intestacy. So, earlier I mentioned that if you don't have a plan, then Colorado law determines what happens. So, that's what is known as intestacy. Those are the Colorado intestacy laws. If you pass away without an estate plan, then you die intestate. And if you're intestate, you have to go through the probate process, and the court looks at the Colorado statutes and figures out what's going to happen to all your property. You have no control over it. Another thing that could happen is that a surviving spouse with no children could end up sharing your estate with your in-laws. Maybe your spouse is going to leave a big chunk of your estate to her brother who you couldn't stand while you were alive, something like that. Surviving spouse with children, um, may get the same share as a child or may not get any share. And this is one of the funky things about Colorado intestacy law is that just because you're married doesn't mean that your spouse is going to get everything when you pass away, is basically the best way to think about it. And so I talk to people pretty frequently who tell me, I don't need a will because I'm just going to give everything to my spouse anyway. And then we start talking about it. And then we realize that not everything under the Colorado intestacy laws would have, not everything would go to their spouse under the Colorado intestacy laws. Another consideration is that under the intestacy laws, children are usually treated equally. Uh, but I have a lot of clients who actually don't want to divide their estate evenly between their children. Maybe one child is just going to be in more need of resources than another child. Maybe the parent has already helped one child, has bought them a house or something, and so they don't want to leave equal shares to their children. Uh, Also, if you don't have a will, then the court could get involved in appointing things like guardians for minor children, appointing administrators, and things like that. So, when should you do a plan? Now, being an estate planning attorney, I'm going to tell you as soon as you turn 18, you should do an estate plan. Um, Now, most 18-year-olds probably don't have a whole lot, and they probably aren't really worried about what's going to happen to their, uh, their third hand couch that they've been sitting on for years and things like that. Um, so realistically, when should you really start thinking about it? Well, when your first child is born. The big thing here is with an estate plan, we can designate who you want to be the guardian of your child if something happens to you. So once that child is born, getting that estate plan put together is a great thing because then you're not leaving it up to a court to decide who's going to be the guardian of your child. If you have a child who reaches the age of majority and can serve as a decision maker, so say you have a child who turns 21 and you want them to be the personal representative of your state, we can go ahead and set up a plan to make sure that happens. When grandchildren are born, many people want to provide for their grandchildren in their plan. Also, if you have aging parents, or excuse me, you're a parent who is aging, and you have more definite plans, you're really starting to formulate in your mind how you want your estate divided up between your kids. That's an excellent time to do an estate plan. One thing I wanted to mention is when you have a child who is turning 18, it's a really good idea to get powers of attorney set up for them, especially a financial, or excuse me, a medical power of attorney. And that is because at 18, um, as far as the hospitals are concerned and those HIPAA laws are concerned, doctors do not have to give you, the parent, any medical information about what happens to your child. So if they get into a skiing accident, end up in the hospital, the doctor is really not allowed under HIPAA to give you any medical information about your child. So having that healthcare power of attorney in place and those HIPAA authorizations in place will allow you to participate in your child's healthcare if something happens to them after they turn 18. Another good time is if you get a financial windfall. So say your rich aunt dies and you inherit millions of dollars. Excellent time to get an estate plan put together. If you have the death of a spouse or a child, that's another time. Anytime that you have just a life event, getting married, having a child, getting divorced, the death of a family member, it's a great time to um, step back, take stock, get that plan made, or if you have a plan, review it and get it updated. Okay. Um, should you review your existing plan? Like I mentioned before, I recommend that you review your plan every year, even if it's just for 20 or 30 minutes sitting down with your spouse. Just review the year. Ask, have there been any major changes that are going to affect our plan? Also, if you don't remember creating instructions for disability anywhere, um, if you think that you lack any of those documents that are part of that comprehensive estate plan that I mentioned earlier, um, if anyone who you named as an agent in your power of attorney or as an executor in your will or as a trustee in your trust are no longer the best choice. Maybe you had a falling out with your brother who was your executor, or you named your father as your healthcare agent and he's now getting older and dementia's starting to set in, something like that. Um, another excellent time to get your plan updated. All right. And so, in summary, right, the goal of estate planning is to take control. Remember, if you don't have an estate plan, then Colorado law and Colorado courts are going to make all those decisions for you. Estate planning is an effective and efficient way to meet your legacy goals. Um, Estate planning is also a critical part of any comprehensive financial plan. I've said it a few times, I'll say it again, right? You spent your life building up this estate, all of these financial assets, and you're talking to a financial planner to make sure that everything is set up perfectly. You've talked to Nicole and you own your dream house. Your estate plan um, is what helps you make sure that all of that stuff is going to the place that you want it to go. It's going to to your family members that you want it to go to. And selecting the right attorney makes a difference. Um, most attorneys will offer free consultations, not all. I know some estate planning attorneys who don't offer free consultations, but most do. And there is no harm in talking to multiple estate planning attorneys to find one that you like. Like I mentioned before, I've even referred people that I've done consultations with to other estate planning attorneys. And I know that other estate planning attorneys out there do the same thing because I get referrals from them as well. It's a great community. I don't think that you're going to have a tough time finding an attorney, but there is no shame in talking to 3, 4, 5 different attorneys until you find one you like. All right. And that is the end. Um, I am Scott Grayson with Grayson Law Estate Planning. There's my contact information. If anybody has any questions, please don't hesitate to give me a call or send me an email, and I will be happy to help you out.
Thanks so much, Scott. That was great. There was so much good information there. I took tons of notes. Um, I think one of the main takeaways for me was that comprehensive estate plan and like how many documents are actually needed with the medical power of attorney, the durable power of attorney, and all these other things. I think we often think we just need a will or maybe a trust, but there's really so many other documents that we need to focus on in terms of the incapacity piece, because that can happen too. Like, I mean, I know you had the example with the guy who ended up in jail, but in terms of like just not being available or not, being in a position to take care of yourself, it's important to have those documents in place. So thank you.
Mhm.
Also kind of you talked a little bit at the beginning about fostering family harmony. And I think that's just really important. And again, at the end, you kind of reiterated that like you work so hard all your life to make sure that, you're providing for your family, you're setting things up, you're, maybe buying that dream home and making sure your kids are in school and are safe. And this is really that piece that you need to continue that legacy and make sure that that same harmony exists after you're gone. So,
Mhm.
um, yeah,
Exactly.
lots of good takeaways. I'll send, I'll put a little, recap in the notes there. So if anybody, has other questions, they can also hop in there and, Scott's information is here. He's a wealth of knowledge. So, if you are interested in getting started on this path, he is a great a great contact to make. Um, and thank you again for joining us tonight.
Yeah. Thank you for having me. I appreciate it.
All right, that's it for us. Hope everybody has a great night and we'll see you next month.